following slides will provide a brief but in-depth analysis of the ethical and legal issues regarding Intel's intellectual property theft in 2008. The details of the case are as follows. On June 8, 2008, an Intel engineer by the name of Biswamohan Pani stole approximately $1 billion worth of intellectual property and trade secrets from Intel. He did this by emailing himself 13 files which contained information about the newest microprocessors being developed at the company. The theft happened just after Pani began working for AMD, Intel's main rival company. For 9 days, Pani was employed by both companies. Soon after Pani left Intel, the company suspected that he had stolen some documents, and they contacted local authorities. Interestingly, Pani had not shared any of the documents with AMD that he had stolen. This was because he knew that the trade secrets would make him an invaluable asset to his new employers, which would then help him level up in his new company.
Now this clearly leads to a very clear-cut violation of Section 72.2I and 77.4 in the Professional Engineers Act, because the Intel employee had an undisclosed conflict of interest, and the employee was attempting to further his own career by abusing the responsibility that was bestowed onto him by Intel. The employee failed to make prompt, voluntary, and complete disclosure of an interest, direct or indirect, that might be in any way construed as prejudicial to the professional judgment of the practitioner. So for about 9 days, this employee was working for both Intel and AMD. Neither of the two companies were aware of this, so this obviously leads to a violation of Section 77.5 of the Act. A practitioner who is an employee engineer and is contracting in the practitioner's own name to perform professional engineering work for other than the practitioner's employer. Section 72.2J of the Act says conduct or an act relevant to the practice of professional engineering that, having regard to all the circumstances, would reasonably be regarded by the engineering profession as disgraceful, dishonorable, or unprofessional. The actions of the Intel employee were unprofessional and disgraceful to the engineering profession because he stole company secrets to advance his own career and simultaneously worked for two different employers without informing either of them. The first three alternatives shown on the screen could have eliminated any moonlighting or conflicts of interest. The last option, however, is not favorable because it is against the Code of Ethics. Here are some of the steps that I would have taken had I been in this situation. The first step would be to inform management of my desire to change employers, and then determine if a non-competition clause is needed. Finally, I would not have knowingly stolen company secrets, and I would have made a graceful transition to AMD. If this engineer was part of the PEO, he would be stripped of his title of PEng, he would no longer be allowed to practice engineering in Ontario, and he could also be issued a fine by the PEO. There is one main ethical dilemma in this case, and that is that to what extent can one benefit from past experience working in another firm in order to benefit a future firm? The employee has split loyalties between his previous and future employers.
There are a few important legal issues regarding this case. Among these are the duties that Pani had to Intel. There are two duties that Pani did not abide by. The first was duty of loyalty, which is the employee's duty to do what is in his employer's best interests. By working for AMD before leaving Intel, Pani put himself in a position in which he was able to derive personal benefit from decisions made in his capacity. This is the very definition of conflict of interest, which was his duty to avoid. The second duty was the duty of confidentiality, which is not using confidential information in a way that could harm your company. The area of law that this case concerns is trade secret law, which is a branch of intellectual property law. Trade secrets include any valuable business information that derives value from its secrecy. So for instance, information that is not public and information related to development. One may think that there would be a breach of confidentiality, which is when sensitive information is disclosed to a third party without the client's consent. However, since Pani had not actually shared the trade secrets with AMD, he was not necessarily guilty of a confidentiality breach. It is still relevant that he intended to use confidential information to benefit himself personally and potentially AMD. When the case went to court, Pani pleaded guilty to 5 counts of wire fraud. He was sentenced to 3 years in federal prison and given a $17,500 fine. What the case ultimately came down to was the question of how much damage was caused. Although Pani's motives were selfish, they were ultimately not pernicious. He had not caused nearly as much damage as he could have caused had he shared the documents with his new employers. Because of this, we have a relatively victimless crime, since he did not end up being able to follow up on his intended course of action.